Mother turned off child support for 2 years, and now after a disagreement is going after back child support. Is there anything I can do? That's the question that we received through our Facebook or through our YouTube videos. What can I do after the mother turned off child support for 2 years? Okay, so it sounds like there's a court order in place, perhaps for custody, visitation, and child support. And that in this case, the father is ordered to pay child support. However, sounds like contrary to the order, they started exercising visitation a little bit different, started going to a 50-50 schedule. And then during that time frame, she's like, don't worry about child support. Now they have a disagreement. She's withholding the child from him, and she says, I'm going to go after you for 2 years of back child support. What can be done? So first off, you're in a very bad position. Mistakes were made. What you should have done is, if there's going to be any change of visitation where now you're getting a lot more time, file for a modification with the court. While you're in agreement, it's the best time to do it. You have an agreement, it's drafted up, you both sign it, the judge signs it, you file it, that's the new court order. That would also then modify child support to put it down what it should be under a 50-50 schedule. Sounds like that didn't happen in your case. So now you're in the predicament that you're in, which means child support cannot be modified retroactively. So if you didn't file for a modification, the child support order is what it is. Even though you were 50-50 for the last year, and even though she said don't worry about it, the court order is what it is, and generally the courts enforce it as it is, and they can't modify it retroactively. But there's still something you can do. What you would want to do is, obviously, if there's been changes, file for that modification. Separate from that, when dealing with the 2 years of back child support she is trying to enforce, you'd want to file a motion to determine that arrearage. Now, the law says you can't modify it retroactively, but there are what we call equitable arguments or fair arguments where you would want to argue to the court and say, yes, the court order says that, yes, I technically owe that, but you shouldn't enforce it because the child was residing with me half of that time period, and she told me don't worry about the child support. So it wouldn't be fair to enforce this order. You can make those equitable arguments. There's just no guarantee the court will go along with it. You're not entitled to those arguments, but or you're not entitled to that as arguments winning the day, but you do have the equitable arguments can be made, so you should make those. Sounds like you're in a complicated situation, though, so you definitely are going to want to talk to an attorney privately and confidentially, get legal advice more specific to your facts. To get that scheduled with an attorney at my office, you can go online to makelaweasy.com.